You see what I have to deal with, Mr. Hansinger? Okay, we're live on YouTube. For the record, this is position number 107, State of Georgia versus Quentin Cortez Pinkston. Mr. Pinkston is charged warrant number 2022 WA 15727 with committing the offense of obstructing or hindering a law enforcement officer. He's also charged in warrant number 2022 WA 15728 with committing the offense of terroristic threats or acts. Mr. Pinkston is present. He's represented by counsel, Mr. Rogers. The state is present. It's represented by counsel, Mr. Hansinger. Mr. Hansinger, swear in your witness and present your case.
Yes, Judge. State calls Officer Demons. Officer Demons, can you raise your right hand? You swear or affirm testimony you're about to give in this matter is truth, the whole truth, nothing but truth, so help you God?
Yes, sir.
You can lower your hand. Can you introduce yourself and spell your name for the record?
Officer Demons, Officer Gardner Demons, Jonesboro Police Department.
And Officer Demons, you indicated you're employed by Jonesboro Police.
Yes.
How long have you been with Jonesboro?
Approximately 1 year.
Were you with them? Were you working with them on October 12th of 2022?
Yes, sir.
And were you in uniform?
Yes, sir.
Okay. On that date, did you have occasion to respond to the Wells Fargo?
Yes, sir.
Okay. Is that located on 154 South Main Street in Jonesboro?
Yes, sir.
Is that within Clayton County?
Yes.
Okay. What was the nature of that call?
A disturbance call. Got a call that a guy was there causing a disturbance. So when I responded, the bank manager gave me a briefing on what was going on, and they was asking Mr. Quentin to leave the property because they could not cash his check. And he said if he don't cash his check, he's going to blow up the bank. So as I waited for him to finish his transaction, I asked him to have a seat so the bank manager can issue him a criminal trespass. So as I was trying to ask him to have a seat, he looked at me and said no. He took off running out the back door. As I gave chase to apprehend him, he slammed the door in my face. So chased him throughout down South Main Street to our new police headquarters on South Main Street, on Smith Street, and where I caught him at.
Okay, so let me break that down a little bit. When you arrived, you were called out for a disturbance at the Wells Fargo?
Yes, sir.
And did you speak to, you indicated the branch manager. Do you remember her name?
No, I couldn't pull up the report because it was so short notice and I'm working right now.
Okay. Do you remember speaking to anyone named Sharon Bartley?
I think that might be it. That might be her name.
Okay. And you indicated that the bank employees indicated that the defendant was attempting to cash a check.
Yes, $40 check or something like that.
Did they indicate why they were unable to cash that check?
Not that I can recall.
Okay, but they told you that they told the defendant they were not able to cash his check.
Yes.
And it was at that time that the defendant indicated that he would blow up the bank if they didn't.
Yes.
And when you indicated you told the defendant to have a seat while the manager was getting the criminal trespass prepared.
No, I asked him to have a seat so she could come out, so she could tell him that he's not allowed to come back to the bank. So then I was going to issue this, but we didn't get a chance to that because he took off running.
Okay. So when you told the defendant to have a seat, it was at that point that he fled?
Yes.
Okay. And you gave pursuit at that time?
Yes, sir.
Were you giving any verbal commands to the defendant at that point?
Yes.
What were your commands?
Stop, just police stop. That's about it.
Okay. And again, you were in uniform at that time?
Yes.
That's all the questions I have at this time, Judge. Thank you.
Mr. Rogers.
Thank you, sir. Officer, just I guess a few questions. To your knowledge, is there any sort of video or audio of the incident?
Yes, my body cam was on, and I guess the bank surveillance.
Have you had an opportunity to review the bank surveillance?
No, I don't think they provided it yet.
Just to make my question a little more clear, I know you said that your body cam will have surveillance. As
Yes.
far as the part regarding, I guess, the call that you responded to, the part that happened before that, are you aware of any video or audio of that part?
No, I'm pretty sure the bank has surveillance of it, but I don't have a copy of it. Unless they turned it in, I don't have any idea about that.
And this stands, I guess, just so I'm clear, it doesn't sound like Mr. Pinkston really made any statements about the situation. He just took flight. Is that correct?
Yes, I asked him to have a seat. He looked at me, said no, and he ran out the door and slammed the door in my face as he ran out.
And at the time when you asked him about having a seat, I guess at that time, had you told him he was under arrest or anything?
No, no, he was not under arrest at the point. I was just trying to get all the good information from him and her. Then that's where it's gonna go from there.
No further questions at this time, Your Honor.
Mr. Hansinger, any follow-up?
No, Judge, state rests at this time.
Okay. Mr. Rogers, are you going to present any evidence?
No, sir, just argument.
Okay. Mr. Hansinger, are you going to waive opening?
Yes, Judge, state waives opening.
Ms. Rogers, the floor is yours.
Thank you, sir. I guess first thing I would say is I don't recall. I usually make a note if Clayton is actually testified to as the venue. So that'd be my first grounds for a motion to dismiss would be that I don't recall hearing venue testified to. Additionally, there's no discussion of any corroboration of the terroristic threats. It's not even really clear who's supposed to be reporting that this threat was made. There was some discussion of speaking with a person, but it was not that person said that this threat was made. There's certainly no corroboration as far as any other name even mentioned to say that person heard any such statements about blowing anything up. None are attributed to Mr. Pinkston. Furthermore, so I would be asking for a motion to dismiss the terroristic threat specifically for the fact that there's just no evidence of that. That has been offered thus far. As it relates to the obstruction, I would say that at the very least, Mr. Pinkston is not under arrest. It's not clear that anything was conveyed to him that would indicate that he was not free to leave at the point that he left. Regardless if he can run, skip, he could do the cabbage patch, the worm, whatever. However he chooses to leave, if he's free to leave, it doesn't matter how he does it. So the fact that he runs off or anything like that versus walks off, gets in the car, none of that matters. If he's free to leave, he's free to leave. And the method of leaving doesn't change that. There's nothing even that really makes it 100% clear that he should have known or had any idea other than that the officer asked him to have a seat, which again, short of a lawful reason, and one that Mr. Pinkston had reason to know of, the officer can ask anybody to have a seat. That don't mean that they have to do it. That's part of being free to leave, is that just because they ask you to talk to them, ask you to have a seat, ask you to stop, if they don't have a lawful basis to require that, you're free to leave. So for all those reasons, John, at this point, it's not clear that there was probable cause to arrest on a terroristic threats charge, so that's not an obvious basis to detain him. The criminal trespass, I understand what the officer was, trying to do, so I don't want to make it sound like it's a criticism of the situation or anything. Just legally speaking, I don't know that Mr. Pinkston was required to stay, or that there's been a corroboration of a terroristic threat. So for those reasons, I would ask that all charges be dismissed for lack of probable cause.
Mr. Hansinger?
Yes, Judge. In terms of the venue, if Your Honor recalls, it did ask whether or not the location was in Jonesboro and then whether it was within Clayton County. The officer gave affirmative answers to both of those. In terms of the snare at this point, Judge, again, we're only looking for probable cause at this point in terms of the corroboration of the terroristic threats. There's been sufficient testimony in terms of that the bank employees had told the officer in this case of that threat to blow up the bank. So there is sufficient evidence there in terms of, the officer being told that that's what had been heard by the bank employees. In terms of the obstruction, which is the basis for the terroristic threats, it's rises to the level of felony terroristic threats as charged here under the statute, because it is a threat to use an explosive device to destroy property. Whether or not he actually had the means to carry that out is not required. In terms of the obstruction charge here, the officer testified that he was in uniform and that he gave a lawful command not only for the defendant to have a seat and wait, which he certainly, that's an indication that he is not free to leave in that moment. It's in terms of whether or not he was lawfully detained, that's something that could be taken up at a later date. But in terms of the evidence here, certainly was a lawful reason that the officer would detain the defendant, given that there was the allegations of those threats being made. He certainly has the legal authority at that point to detain the defendant so that that criminal trespass can be carried out at that point. And further, when the defendant then begins running away, he refuses the lawful commands of the officer to stop fleeing. All of those are lawful commands that the officer had at that moment in his detention of the defendant in this case. So the state asks that you bind over all charges in this case as there is sufficient probable cause.
Okay, so I do have questions. And is the obstruction or hindering charge to me is that's clear at this stage. Terroristic threats, I have two questions, and I'm gonna invite both you, Mr. Hansinger, and you, Mr. Rogers, to further educate me. Terroristic threats to blow up the bank. Is that first question is that a misdemeanor or felony? That threat. The second question is, I mean, assuming statement was made, is whether it does at this point amount to a criminal offense. And I'll start. The reason the obstruction is an easy call for me is because Officer Demons would not have been called out but for there being an allegation of something wrong. So now I want to go down the decision tree as it relates to terrorist threats and whether the threat, assuming it was, or the statement, assuming it was made, whether it constitutes a felony, and then we'll get to whether the statement is something that there is proof, as Mr. Rogers brought up, as to someone being able to say, yes, I heard this threat. So I'll start with you, Mr. Hansinger.
Yes, Judge. The statute in this case escalates a terroristic threat to, which is OCGA 1611-37, escalates it to a felony when the threat suggests the death of an individual at that point. So blowing up a bank, with people inside of it, clearly is going to suggest the death of those individuals. And it can be, an instance of an act of violence or just burning property. The suggesting of a death is going to probably have to be an act of violence. So we would have that here with the, blowing up of a bank. In terms of I believe Your Honor was asking about the corroboration aspect of it.
Yes.
Yes, there is a jury charge if this case were to go to trial, stating that though the testimony of a single witness alone is sufficient to convict, the exception applies for this case. There has to be some corroboration, doesn't necessarily have to be another individual, but it can be facts and circumstances that support the threat. But that's a jury charge that ultimately, is handled at the in terms of a conviction. There has to be some form of corroboration in order to be convicted of that.
And I believe the testimony was that Officer Demons, he had his body worn camera on, but he may not have been there to hear.
Correct. But presumably, I mean, there's other people in the bank, things of that nature. So I believe Attorney Rogers asked about whether there's a recording. At this time, the officer wasn't aware of there being a recording. But any of those elements, whether there was a recording, a second individual who heard the allegations, any of those things would be sufficient corroboration at the time of trial to support a conviction in this case.
Okay. Mr. Rogers.
Yes, sir. I guess I would start as it relates to the terroristic threat and whether or not it would rise to the level of a felony. I know there was some discussion about whether or not a person has been to carry out the threat, but I'll say in this case, it is relevant in that the threat is to the bank, the building. Unless a person is talking about blowing it up during business hours as opposed to after business hours, which that's why I say the fact that there's no indication that a person there's no real commentary on when this is supposed to happen or how or any of that as far as business hours or anything like that. So it's it would turn on whether or not any structure is occupied or not at the time of the alleged threat, or at least when it's supposed to be carried out or whatever the case may be. The person wanted to say, I was going to try to kill somebody or I intend to kill somebody, could have said that. He didn't try to blow it up. There's no indication they had any capacity to do so at the time. So to say, the implication is not that it was supposed to happen at that time, at the very least. Additionally, as it relates to the idea of the corroboration, I guess I would say that to the extent that what ADA Hansen has said about the possibility of video or other people being, offered at trial, point is that none of that's been offered yet. It's just that somebody said something. And again, like I pointed out that I understand this is a hearing where the standard is probable cause, but just because the standard is low doesn't make it non-existent. And so the idea that merely having somebody say something or somebody said something, we're not saying who said it. There's not another person saying, I heard this person say it. I'm not saying this on video. I'm not saying that they admitted to saying it. There's none of these things. So at this point, all we have is somebody said this person said something. If that's all it takes is somebody said this person said something, there's nothing stopping, anybody from being locked up at that point. That's all it takes. So it takes a little bit more than that. And so I would say that the corroboration is relevant for that very reason. And that's why it's important, particularly in a charge like this. Because and the other part of it is, you start getting into people's freedom of expression and the use of colorful language and one person's interpretation and things of that nature. So that's another thing that makes it relevant from a corroboration standpoint.
This is the Terroristic Threats Act actually had a person that was a former elected official that said, I probably commit a terrorist threat every day. And it's language that has become too common. And people get to the point where they threaten people because that's just the going currency. I think it's enough for this terrorist threats charge to get bound over. But I don't take any joy or pride in that. And I think statute says what it says, and we got to get to a point as a community where we're not making these threats, and that this is just something that you feel comfortable saying. So I'm going to bind both charges over to the Superior Court, Clayton County. I do believe it's a close call, but that's going to be my ruling.
Thank you, Judge. Can Officer Demons be excused?
Yes,
Okay, thank you, Judge.
you're welcome. Have a good day.
You too.
All right, what do we have next?
Judge, may I have a breakout room with the jail to speak to Mr. Tiskovich?
See, you can't pronounce the name.
I can. I'm gonna get it right.
Yeah, yes. The answer to your question is yes, and I believe, because I do remember him and he had 2 other warrants